The research that led to the writing of the book began quite a long time ago when I started to ask myself the question, what happens, what happens in respect of the common law, and does the common law impact on Aboriginal people in this area, in the area of inheritance, in a way that's different from the way it might work for non-Indigenous people. And so I started looking at things like intestacy, which is what happens when you don't make a will. And I was very concerned to find that the intestacy provisions in Australia generally were completely inadequate for Aboriginal people for various reasons. The first thing that I discovered was that there were some states in Australia who had special provisions for Indigenous people, but in fact those provisions that looked as if they allowed for culturally different things to happen ended up not really letting that happen. So that was a problem in itself. And then the Northern Territory did have a provision that allowed Aboriginal people to come to them and say, we have this particular way of doing things, can we do it? And that provision worked somewhat, though it had some factors in it that prevented it from working the way it was really supposed to. Anyway, eventually we got a provision like that into the New South Wales legislation and into some of the other jurisdictions. So that was good. However, it still didn't deal with it still was a bit complicated, a bit difficult, and there was still a problem. So the problems that I discovered really arose when you had intestacy for Aboriginal people were these. The first one was that Aboriginal people often have a sense of who's in their family that's quite different from the mainstream Western way of thinking who's in the family. So the easiest way to explain this is to say that, for example, in Western ways of thinking about relationships, we're very focused on blood relationships. So we're very focused on whether so-and-so was born of so-and-so and so on. And we go in a line from the distant past right down to the present. In many Aboriginal groups, and of course it's complicated by the fact that each Aboriginal group is different in how they deal with these things, that's not so. They may have a sort of a circular view of time, and so there may be more than one person in different generations who bear the name spouse or something like that. And they also very often have a situation where, for example, people that I would call my niece and nephew would be regarded as my children. Now, you can see that if we have intestacy that says you pass it to your children, and I mean by my children a different group of people from the position in an Aboriginal community where somebody might think more people are their children, if the common law of intestacy applies to them, that's going to mean that the wrong people can inherit. And this matters because we tend to think that our obligations to somebody, we tend to think we owe an obligation to our children in the way that we don't to our niece or nephew. And the same applies. If you have children that the law doesn't really recognise as children, you will feel that you have obligations to them, but they're not going to be met by the existence of the law. So that was one problem. The second problem was a really big one, which was about arguments about where somebody could be buried after they died. And this is a really big problem. In Aboriginal communities, it causes enormous problems. And it became clear to me just from looking at the cases that around 70% of the cases which were about disputes about burial involved an Aboriginal person. Now that's completely disproportionate from the population of Aboriginal people compared to the population of non-Aboriginal people. So if you've got about 70% coming from a group that's really 2% of your population, that's telling you that something big's happening. The problem is that when somebody dies intestate, it's not clear who is entitled to deal with the body. Whereas if you make a will and you appoint someone as executor, generally it's regarded by law as that person having the control of who is going to be of where somebody was buried, how they're buried, and so on. So that was another problem with intestacy, that with intestacy, people were unlikely to be able to solve these disputes about burials. So I worked out all this. So in terms of my research and how I did it, I also looked at a number of things like passing on customary law matters and protecting them by putting them in a will and therefore being able to keep them secret and so on. And I did all this sort of legal research in the form of bookwork, going and looking up cases and statutes and so on, and then thought, well, there's an issue here. Then when the Public Trustee of New South Wales approached me wanting to do something, he'd read some of my articles and they wanted me to do something on this area. I was really concerned that we not sort of create something and then just sort of say to the Aboriginal community, look, here we are, we know what you need, here it is. So what we did was we went round to Aboriginal communities all around the state and had long meetings with people and asked them what they were really concerned about. So what was the thing for them that they worried about in relation to death and burial and passing on of property and so on. And that was really interesting because I ended up with this idea that what they were interested in was seeing wills as a way to resolve disputes. Now, we don't usually think of wills as a dispute resolution device. That's not a normal way to think of it. But it became clear to me that that was actually what was really important to the people in the Aboriginal community that I consulted. And also that when I talked to them and they said what the problems were that they were concerned about, in the burial one was a really big one, because every community that I went into had at least one dispute. Some of them were very old, some of them involved something that happened 30 years ago and people were still not speaking to each other about it. So it was a really big problem. I found that having talked to them, that was the really number one thing. And then some of the other things, they were concerned about who got what and whether the kinship patterns matched properly. They knew that that was a problem. There was also the fact that I hadn't realised, which was that lots of Aboriginal people thought you couldn't make a will unless you had a lot of property, like you owned a big house or you owned land or something like that. And another misapprehension was that people thought that you inherited debts. And obviously most people don't want to inherit debts. So that was another barrier to people making wills. So after this consultation with the Aboriginal community, I went back and with the New South Wales Trustee and Guardian and people from there, we put together this book, which is basically a package that's designed so that an Aboriginal person can pick it up and look at it and see basically what problems could be solved by doing these things. And then the other half of the book is something which they can take to a legal practitioner and it will explain to the legal practitioner what can be done to make a will that's culturally appropriate. And there are some things that most people who are used to practicing in this area will habitually do that they shouldn't do when they're dealing with an Aboriginal person. So it's really important that you can get the lawyers to learn these things as well. So the book's in these two bits, and because it's in those, and because of the way it's designed to be used by people, and that's why it's free, that's why it's copyright waived, and that's why it's available from the New South Wales Trustee and Guardian website for download completely, because we think it's really important to increase the rate of will making in the Aboriginal community, because not just me but also the people I talk to in the Aboriginal community think that this will really help for the future.